Mr. Hughes, could you give me the example of how a provision, an exhaustion provision, would have to be worded to limit the court's jurisdiction without using the term jurisdiction?
Your Honor, I don't think I have an example, but I do in this statute, when Congress wanted to speak in jurisdiction in 12 other places, it used the phrase, no court shall have jurisdiction, and I think that's pretty statute-specific evidence that when Congress meant to use jurisdiction in the statute, it had the language at hand.
So it really does seem like you're arguing for a magic words rule. And haven't we said that magic words are not required?
Oh, certainly, Your Honor, but I'm not talking about the general abstract of what applies in every case. I'm talking about in ARERA, when Congress wrote this statute, it was fixated on what is going to be jurisdictional and what is not going to be jurisdictional. It had that language at hand, and it used in this statute very precise language.
So if all that we had before us were the language of the provision, would it be jurisdictional?
If we knew
we
nothing.
have a provision that is worded exactly like this provision, but we don't have D2, we don't have any of your other arguments, we just have the language. Would that be a jurisdictional provision?
I don't think it necessarily would, but in undertaking the clear statement test, this court says it looks to all of the traditional tools of statutory.
Well, why would that language not be sufficient?
Well, Your Honor, I don't.
Because it doesn't include the word jurisdiction.
Well, in this specific context, that's right, but also in describing the context of review, that there is ambiguity in that language because review, it can mean in certain contexts an equivalence of subject matter jurisdiction. But it can.
No, I'm sorry, go ahead, finish.
It can also describe what it is a court is to do in the course of reviewing things for which it does have subject matter jurisdiction. So I do think there is inherent ambiguity there. But again, we don't look at just this one issue. We look at all of the traditional tools of interpretation, and I think that shows that, again, my burden is not to say that our argument is the better one. The court was quite clear in Batchelor saying that's not the test. It's the government has to show their interpretation as jurisdictional is the only plausible argument for them to demonstrate that. And again, if we're wrong about this, it has the effect of delegating to agencies the ability to make rules that have jurisdictional character.
All right, if we look at one of our own prior decisions handed down during the bad old days when the court was not disciplined about the use of jurisdiction, and a provision is described as jurisdictional, does it follow necessarily that that provision is jurisdictional?
I don't think that it's necessarily the case if a court did something that I think Arbach calls a drive-by.
No, it's not a drive-by. It's a pretty clear statement in the case describing this as jurisdictional, the issue, and the court says it's jurisdictional.
Well, I think the court would have precedent to decide if it's going to adhere to a prior pronouncement of this court or if there's a basis in changed case law to revisit that. So I think that normal process would apply. But if the court is held that it's jurisdictional, not just in a passing statement, but in a reasoned holding, that's going to be binding.
Well, I'm just wondering if I could. I'm sorry. One more follow-up, then I'm done. If that's so, then why would you even concede that a statute passed by Congress in the days when the court and Congress were using the term jurisdiction in some instances to talk about claims processing rules, why would that even be sufficient?
Well, I'm not sure I need to say that your argument goes that far. I think it's well understood that in this statute, in ARERA, Congress used jurisdiction, in a particular way. That Congress did, in fact, have jurisdiction stripping in mind in 1996. And in this statute, Congress was not using it in some loose sense of the word. It knew what it was doing in the statute. It just used the jurisdictional language when it wanted to here.